Hi friends, and welcome to the lecture 4 of contracts. Today we'll discuss about a very small but important topic related to Indian Contracts Act. This topic is a part of various examinations and it is asked in various interviews, and majority of us we are confused about it, all the legal professionals, that what exactly it is. The students related to law, they are confused what is a quasi contract. Quasi is a concept, it's a word which you will find in the even the engineering students, they find what is a quasi determines which is not fixed any state in electronic circuits also, which toggles from one to two states. So it's not fixed. Quasi crystal, quasi devices, lot many things in engineering you see. Similarly, in the field of law, you will find the quasi contract. What it is? It's not a fixed contract, but it is still legal. So we'll discuss today about it. So first of all, we should see where it is stipulated in the act. So if you see the Indian Contract Act 1872, it is mentioned from section 68 to 72. 68 to 72 of Indian Contract Acts talked about quasi contract. So what is a quasi contract? As a general definition, we should see, because I gave you some of the idea of this quasi contract in the second lecture also, that quasi contract is based on coincidence. Coincidence means there is no prior intention to have a contracting, and it just happens. I'll give you an example. You are at your home, your bell rings, and when you open that, there is a pizza over there, and there's nobody. It was a delivery from Pizza Hut. So you are clueless what to do. You take that pizza, you take it inside, you wait for half an hour. Nobody comes back to take that pizza. So now what can you do? You cannot throw it out. You cannot return it to somebody because you don't know who delivered it to you. What you do? You just wait for some time, and then instead of wasting it, you consume it. Now once you have consumed, the bell rings after half an hour again, and the person is at the gate, and he says, "Sir, sorry, it was a mistake. I delivered it to you by mistake. Now please return it to me." So what you will do now? You will tell that I have already consumed it. Then what is your obligation? Not a contractual obligation, but the obligation due to morality or the natural justice. What you should do? Yes, you should pay him for the services he has delivered to you. Now, was there any offer? No. Was there any acceptance? No. Then was there a contract? Yes, because if there is no contract, how can you pay him? Why you have given him the consideration? So this is the principle of a quasi contract. Means contract by coincidence. No prior intention. But consent is there because you are paying him, there's a consent from you. And in some cases of quasi contract, there is some coercion also, means you are forced to do so. If you find something, then the person calls you, he says, "Hey, it's my purse. If you find it, please, I'll pay you 100 rupees. You please deliver it at this place." You say, "I can't deliver it." But he forces you that, "Please deliver it. It's important to me. I cannot come. I'll pay you." It's a contract, it's a coincidence, there's no prior intention, but you are forced to some extent to deliver it because, again, on the basis of natural justice and morality, and because the person is aware that you are now holding his purse. So such cases, there is some small minor factor of coercion is present, but the typical thing is that there is a coincidence, there is a consent, there is no prior intention, and offer and acceptance definitely is not there, but the agreement still exists. Now, the concept of natural justice is the basis of quasi contract, as I just elaborated. There's a Latin maxim which governs this, and that maxim is nemo debt loco pletari ex aliena jectura. Nemo debt loco pletari ex aliena jectura, which means you will not benefit from the loss of others. Means if somebody did a mistake or by coercion, somebody gave you some service or paid you even some money, you are supposed to return or repay it because it's a natural justice. And the basis of this is equity, good conscience, and morality. Now we'll go to what the Contract Act says about it. Section 68 says, with respect to an incapable person, it says that if an incapable person, for example a minor, if it is held by a capable person, then such capable person is entitled to be reimbursed from the property of such incapable person. So the right or entitlement of a capable person for helping somebody who is incapable or minor, it gives him an entitlement to get a reimbursement for the services he has given. Section 69 says the right of reimbursement or recovery of a person who paid on your behalf. If somebody pays on your behalf, it is his right to ask the reimbursement or recovery of that payment, what he has done on your behalf. Section 70 says obligation of a person to return another person for enjoying the benefit of non-gratuitous act. The example of pizza which we have discussed, it was a non-gratuitous act, it was by a mistake. So it is the obligation of the person who has consumed it to enjoy, to return for the enjoyment of the benefit he received. Section 71 is very important. It talks about duty and responsibility of the finder of goods. If somebody lost some goods and somebody finds it, then the person who's finding the good, what is his duty or responsibility? Such person has some duties, and those duties are to take reasonable care of the good. First of all, you received it by mistake and somebody lost it. You keep it safely, have reasonable care. And the second is not to use the good for the personal use. Don't use it for yourself. Third is not to mix that found good with your own goods of the similar nature. If you have, you try to mix that and then you try to make something out of it. So that becomes illogical or irrelevant. And the last one is to, which is very important, to make reasonable efforts to deliver the good to the actual owner. So these are some of the duties of the finder of the goods. But at the same time, the person who finds the good has been given some rights also, and that are quite interesting to know. Because the right of the finder is, the first right is right to sue. He can sue for certain legal inconformities. But more than that, he has a right to lien. He can lien the item, he can hold the founded good until he's paid a suitable compensation. So it's your right. If you find something and somebody comes and asks you to please deliver it or return it back, you can ask for a compensation. You can ask for a reward, a suitable compensation, not illogical or unexpected. You can ask for something suitable as for giving the services, because definitely you will be putting your efforts, time to deliver it back. So you have the right to lien until you are paid a suitable compensation. You have a right to sell also in two cases. If the reasonable compensation is not paid to you, he denies, then you can sell that item. You can take a reasonable compensation and give him the balance amount. At the same time, if you try your best, to find the person, but you could not find the owner of the good, then you have a right to sell that and use the amount. Section 72 says that a person to whom money is paid or anything delivered by mistake or under coercion, he must repay or return it. So I hope you will be able to understand what the quasi contract is, what are the references from Indian Contract Act. It is from 68 to 72. We discuss each section in detail, and the principle of quasi contract, the salient features of it, and the Latin maxim which governs it. So with this, I'm winding up this lecture. Thanks for your time. Keep in touch. Thank you.